Good afternoon and welcome to our live webinar. I'm Patricia Kovacevic, General Counsel and Chief Compliance Officer at Nicopure Labs. Thank you for your time and your interest. Today's live webinar aims to discuss the impact of the recent FDA Deeming Rule on retailers. And I know most of you already have sent some questions ahead of time, but we also have live questions that are coming in even as we speak. So we will try to answer most of the questions, or at least those that are recurring and those that really have an answer. And we'll also try to give you a little bit of a background as to some of the basic requirements for retailers. As you can imagine, the Tobacco Control Act and the FDA Deeming Rule are very complicated and complex documents, and it's virtually impossible to address everything in one webinar. So, as you know, on August 8th, 2016, a new Food and Drug Administration, or FDA, rule came into effect. The rule brings certain nicotine-containing products and related devices, as well as cigars, hookahs, shishas, under the 2009 Tobacco Control Act, thus subjecting these products, the manufacturers and the retailers, to a series of requirements. This rule is commonly referred to as the Deeming Rule, and I will be calling it the Deeming Rule in this webinar. The Tobacco Control Act has provisions applicable to manufacturers and some other provisions applicable to retailers. So as I was saying, for the purpose of today's webinar, I will discuss some practical applications of those provisions related to retailers and some scenarios that you may encounter in your daily activity. Because we received literally hundreds of questions in advance of this webinar, I really have to apologize for not being able to address all of them. But I hope our discussion here provides some guidance and at least directs you to the right resources for further exploration. Please note that, as always, our discussions do not represent legal advice. Each situation can be very fact-specific, and therefore you should always consult your own attorney if you think you need advice. And also, you should always use your judgment in applying the scenarios discussed here to your own situation. One of the questions that we received really refers to maybe the most basic thing. So there is a question as to what should retailers do or refrain from doing under the new rule. So first and foremost, the Deeming Rule prohibits the sale of what's called covered tobacco products to persons under the age of 18. The rule also requires retailers of the covered tobacco products to verify the purchaser's date of birth by reviewing the individual purchaser's government-issued photo ID. The Deeming Rule defines a covered tobacco product, and that excludes components or parts that are not made or derived from tobacco. But let's talk a little bit about age verification. So everything that is in the Deeming Rule is in addition to and complementary to some requirements that you may already have in your state. So although the Deeming Rule requires that no sales to minors under 18 be conducted, however, in your state, such as California, the age of purchase of these type of products may already be higher than 18. And therefore, you should always comply to all applicable legislation, including your state laws. Therefore, if your state law requires that you sell e-cigarettes to 21 and above, and FDA requires 18 and above, of course, you're going to follow the more restrictive requirement, which is 21 and above. So in order to comply with the age and identification verification requirement, retailers are thus required to verify that a purchaser is at least 18 years of age. And if the person is up to 26, you're required to ask for identification. Retailers are, however, not required to verify the age of any person who's more than 26 years of age. Now, how would that look like in practice? Well, in practice, I would hope if I walk into your store that you will still ask me for ID. it's very difficult to assess if a person is 26. So, it's very difficult to provide guidance as to exactly who you have to ask for ID from. But as a rule of thumb, if somebody looks really, really elderly, probably you don't need to verify their ID. If they look youngish, then you probably should. Again, it's a separate violation not having verified the ID of a person who's 26 and below, and it's a separate violation to sell to minors. So even if the person is not 18, if they're 25, but if you have not asked for ID, that in itself is a violation. In addition to that, the Deeming Rule also prohibits the sale of covered tobacco products through the assistance of vending machines, except in facilities where the retailer ensures that no person younger than 18 years of age is present or permitted to enter at any time. So in sum, I know vending machines are not really popular in our industry, but if you have a vending machine, everybody physically present in the room with the vending machine can only be 18 or above. That brings me to another question that we just received earlier online. So the question is, can I allow in my store a child under 18 to walk in the store accompanied by their parent? And the short answer is yes, of course, provided, of course, that you're not selling the product to the minor, because there is no restriction for access to your store. If your store has a vending machine, though, you cannot allow minors to walk into the store. Another question that is often asked is, do I have to keep these products behind the counter? And the Deeming Rule says clearly that you do not have to keep these products behind the counter, though arguably, if you put them on a shelf that you don't monitor, they can be stolen. But FDA does not require that your products be behind the counter. Bear in mind also that many of the questions that we've received online from you refer to very specific situations. So again, I'm trying to address questions that are applicable to more of you or more of us. The most important thing is about inspection. So we're asked who's going to inspect now. Is FDA going to inspect in addition to state inspectors? And the short answer is for retailer inspections, more often than not. FDA, in fact, will contract with state and local inspectors. So you probably will not see an FDA person walking in your store. It's going to be a state inspector, and they will have been contracted by the FDA to inspect you. And we received a few questions about what powers of inspection does FDA have, and can access to an inspector, for instance, be denied in the absence of the store manager? And the short answer is you should always be fully cooperative with the FDA when they inspect you and not resist inspection. The fact that the store manager is not on site, really that in itself is no reason to refuse an inspection. In fact, more often than not, you will not know that you have been inspected. And you will only know that you have been inspected if there is a violation and if you receive a warning letter. Well, how come? So FDA will typically contract state authorities to carry on retailer inspections. And many of these inspections will be undercover. And how is that going to work? FDA is going to get a minor or a person under the age of 26 to attempt to purchase a vaping product. And note if the retailer asks for a government-issued photo ID, which could be a driver's license, for instance, or a passport. After the failed inspection, and they may not tell you there and then that they're inspecting you, they may just try to make the purchase, and if they manage to make the purchase, basically they will go back to their office, write a report, and you will get a warning letter. If that's the case, the warning letter will stipulate what you need to do, how to correct the violation. It's always a good idea to conduct training with your staff preemptively to make sure this doesn't happen. On FDA's website, which I strongly encourage you and cannot emphasize enough that you should absolutely visit, the FDA website dedicated to tobacco products, there are ample examples of warning letters issued in the past to retailers of conventional tobacco products, which, as you know, have been regulated since 2009. There are probably thousands of those letters. I strongly encourage you to read some of those letters, and also bear in mind on that same website, there are some other resources for retailers, such as examples of how to conduct training, guidance documents. It would be very useful if you can become very familiar with those educational materials on the FDA website. And if you read them carefully, you'll see there are a lot of answers to some general questions about age verification. Another question we've received is any product illegal now? And the short answer is products that were on the market on August 8, 2016 may continue to be sold subject to certain manufacturer's obligations that will occur at a much later date. So it's safe to say that products that were on the market on August 8, 2016 for now are legal. However, after August 8, product may not be introduced on the market without FDA's prior authorization. To obtain an FDA authorization for a new product takes a very, very long time. In fact, to date, only a handful of products, in fact, one type of product, has received a pre-market authorization last December after about 6 years after the Tobacco Control Act was put into place and a good couple of years after the manufacturer applied for it. So you should not expect to see new products on the market. You should not expect to see any authorizations from the FDA for new vaping products because simply FDA has never done that for a vaping product. And it is a long, complex, convoluted application and review process. But products that were on the market on August 8th, subject to a few conditions, may continue to be sold. So for you as a retailer, I would say the rule of thumb is work with a reliable manufacturer and distributor with products that you're familiar with, because that's probably your best guarantee. Also, bear in mind that FDA will never issue a letter of compliance saying that a particular product is legal or compliant. So no manufacturer should be able to come to you and say, oh, I have a letter from the FDA saying that my product is compliant. FDA just does not issue those kind of letters. And truly, there is no way for a manufacturer to approach FDA and say, give me some kind of paperwork to prove to my retailers that my product is legal. That doesn't happen. Conversely, though, if FDA finds that a product is violative, FDA will issue an order that will be public on FDA's website, ordering that product to be removed from the market. So, and that's not likely to happen, by the way, in the next couple of years. Once certain deadlines in the statute have been met, meaning probably about 3 years from now, we might start seeing those letters on the FDA website, orders to have products removed off the market. Therefore, for now, again, there is no proof of compliance that you can require from your manufacturers and distributors. If you want a personal affidavit from a particular manufacturer to say we confirm that our products are compliant, that's fine. But again, FDA will not issue those letters. So again, don't expect any orders from the FDA to remove products off the market in the next couple of years. So what other restrictions may there be? I know that some retailers also mix liquids in their stores, and the question is mixing a liquid a manufacturing activity? I know some other some other retailers relabel products and repackage products. And the question is, does that represent a manufacturing activity? And as a rule, after August 8th, basically you cannot make new products or new types of products without FDA's authorization. So it is everybody's guess that, of course, mixing a liquid creates a new product, and that new product arguably was not on the market on August 8th. So the retail shop owner that either relabels or mixes is really a manufacturer according to the definition of the manufacturer in the Tobacco Control Act. So, that is something that you really cannot do. Well, we got a question about what about products that are in packs of 5 or 10? Can we open them and sell them in singles? And that's a very good question, and there is really no clear answer. I would say the short answer is yes, because really what happens is if you look at a pack of 5 bottles, right, and if you think of a carton of cigarettes, right, the carton of cigarettes, conventional cigarettes, is 10 packs, right? And of course, you can buy a carton, but you can also buy a pack. And that's something that you need to agree between yourself and the distributor, if in fact the distributor contractually is in agreement with you to open those packs of multiples and sell them individually. And that's really a totally different contractual matter. A reason being, you're really not creating any product in that manner. However, again, remember, FDA hasn't really addressed that in any guidance document. I would say conversely, if you put together a few products, and we'll talk about it in a second, that may constitute manufacturing, and I would not encourage you to do that. Also, more importantly, you should not open bottles of liquid, because once you tamper with a product, or for instance, if you have a product such as this one that comes in a pre-packaged box, the moment you open it and you take it to pieces and replace pieces, that also represents manufacturing. And you shouldn't be engaging in that activity at your point of sale, because that makes you manufacture. Now, of course, there are other risks associated with disassembling a product or assembling it. Of course, there's a risk that if the product malfunctions, then you as a retailer, if you have tampered with the product, if you have reassembled the product, you know, there may be some liability associated with that if the product malfunctions. So in other words, if a consumer asks you to put together, you know, take parts of a device and maybe replace battery or reassemble it, or some people asked about what about soldering coils and so on. First of all of that would represent, according to FDA's statements to date, it would represent manufacturing. But more importantly, imagine if that consumer goes home and something happens with the device, if the device blows up. Of course, the last person that has handled the device is you, the retailer, who assembled it for the consumer, and that's a different kind of risk. It's nothing to do with the FDA, has to do with liability. And you may want to think about it before you take that kind of risk on yourself. But again, that's your judgment, your decision. Another question that we receive very often is about sampling. As you know, one of the Deeming Rule prohibitions is a prohibition against distributing free samples. And the question is, are vape shops allowed to charge for sampling, for instance, $1 per juice or per sample? And the answer is, of course. In fact, you should charge, because you're not allowed to give away free samples any longer. Therefore, you should be charging for samples. How much do you charge is your call. My suggestion is that it should not be a trivial amount, such as 1 cent, but certainly you have to charge for sampling. Of course, you should age verify the people you sample. Even if they don't end up purchasing, you really should not be providing samples to minors. So the question we received just now, as a matter of fact, basically is can we have a membership club? Can we have an annual membership fee and allow people unlimited sampling based on that membership fee? And again, that's perhaps a solution that FDA has not specifically addressed in their guidance documents or in their webinars. But arguably, if you can demonstrate that in fact the samples provided under that membership scheme were not free, you probably have an argument to say that in fact you are not distributing free samples. Now, how much you should charge or how many samples you can provide, again, that's your judgment. And again, FDA has never really talked about the value that has to be associated with these samples, and they will never say that. They will never tell you 1 cent is all right, or 5 cents is all right, or $1 is all right. But you have to use your judgment for that. I would argue that it should be a commercially reasonable value for the sample. Now, another question that we receive is, well, how are we going to be able to continue to educate our customers, really? Because of course this is a new industry, and some customers are entirely new to this industry. So how can we still teach them how to replace coils, replace batteries, replace tanks. And I see these activities being very separate from manufacturing. And let me explain what I mean by that. I don't think it's a problem to communicate with your consumers and describe to them how the product works. In fact, you should, how they can replace a battery. You can probably even demonstrate that to them after they've purchased the product. So let them purchase the product and the spare parts, and of course you can then show them how to interchange those parts, as long as they've purchased it, not before. So in other words, I would say do not assemble or do not create a new product for them before they buy it. Let them buy it, and of course you're very welcome to demonstrate how it works. You can also have a sample model. I would rather encourage you to keep a sample model in stock, and you basically demonstrate them on that sample model, and on that which is your own device, which you're not selling. You can show them how to assemble parts. And related to that, we got a question about, well, what about the display model? What about, I had a display model that I opened with a view of demonstrating to my customers how to use a vaping device. Can I then sell that product? And it's a difficult question because, you see, that product really has been tampered with. It's not in its original box anymore. Even if it is, it's been opened, it's been manipulated. It's not how the manufacturer made it. You see what I'm saying? So that's really a problem because, again, you're really not selling something that was manufactured the way it was manufactured. And therefore that could represent a problem. Besides, you know, I don't know about you. You as an individual may want to take the risk about a product and buy it if it's an open box product. But really, in the realm of tobacco products, that's a little bit more difficult. In fact, a product that's been opened and tampered with really arguably is not the same product that was manufactured, and that can create liability. So you have to think about it. But if you have your own store model and demonstrate or show how to assemble products, of course, that is still fine, as long as, again, you're not engaging in manufacturing by creating a new product. So another question we received was about exporting vaping products. And the long and the short is there is no license required, but FDA will come up with additional guidance because the rule in the Tobacco Control Act is if you export a tobacco product, you have to make sure that the laws of the jurisdiction where you export to are being followed. And that sounds a little bit generic, and it's not really entirely clear how FDA is going to apply that. But the long and the short is you need to comply with US laws for products that are sold into the US, and you need to comply with the laws of the jurisdiction where you sell your products. That may be vastly different. In fact, we've had different webinars talking about the European Union and the laws in that jurisdiction. Of course, there's going to be labeling considerations and some other considerations. So I advise you to look into, again, the laws of the jurisdiction where you export. So what about, you know, a generic question such as, I'm a small vape shop. I really don't understand this whole legal stuff. Excuse me, please. How is this going to affect me? And if you follow the law, if you perform age verification, and if you sell the products as provided them to you by the manufacturer, whether they're spare parts, of course you can continue to sell spare parts, you can continue to sell separate coils. Each of them is a tobacco product, and each of them, according to the FDA, is really allowed to be sold until further notice. But you know, if you follow the law, age verify your consumers, continue selling, and keep very good records of all of your sales transactions, the new rule really should not impact your business right away. As a retailer, really, you don't have very many obligations. You really have to follow age verification, not hand out free samples, and make sure you don't have vending machines that are in a room where minors can access it. However, it is clear that this rule will have an impact on our industry in a few years, as some products are going to be ordered off the market by the FDA. Of course, there will be changes in the whole supply chain, but those changes are difficult to predict. I would say of all people impacted, the retailers will be impacted eventually, as the number of products perhaps is going to be reduced. But at present, if you follow the law, really, you shouldn't feel a lot of impact immediately. Another question we received refers to online sales, web pages, and apps for business. Is the app legal if I use an app to sell? And the long and the short is yes. You may continue to use apps or sell online provided you have age verification. So the age verification requirement applies to online sales as well. And really, FDA will not give you a name of a provider or an exact way of doing age verification, as long as you can demonstrate that you have verified the age with a government-issued photo ID. You may also continue to advertise, of course, your business, however, provided that you understand that you will not be able to make certain statements. So for instance, you cannot advertise that a specific brand product is less harmful than another product. And of course, all advertising should be truthful. In the future, at a certain date in the future, and we'll talk more about it when the time comes, but not now, in a couple of years, the advertising will have to have, or less than a couple of years, advertising will have to have health warnings, but not now. So again, you can continue to advertise. Your advertising should be truthful. Do not say that a certain product was approved by the FDA, because simply that's not true. At present, no vaping products have been approved by the FDA, and they won't be approved for a very long time. But that's fine, because the rule provides for that period of time. More importantly, again, in your advertising, make sure that you're not appealing to minors. I think that's a general rule. While it may not be codified in the Deeming Rule, I think clearly you have to bear that in mind, because truly our sales and our communication should be directed to adult consumers, adult smokers, people who are potential buyers of our products. So again, one more question about sampling and about taste bars. What would be a reasonable amount to charge? Do we deduct it off the purchase price? Do we include it in the purchase price? Well, obviously, if the sampling leads to a purchase, you can quantify it in that manner. But more often than not, sampling might not lead to a purchase, so you really have to attribute a value to that sampling itself. And FDA has not indicated what would be a minimum acceptable amount, but it probably should not be trivial. So a cent could be problematic. So there is a question that I tried to address more comprehensively, but it only warrants a very short answer. So the question is, because we're a tobacco product, is it possible that we will need to obtain a tobacco license? And the short and the long is no, because tobacco licenses, as you know them from the cigarette trade, really applies only to conventional tobacco products. And also please note that that kind of licensing and the monitoring that goes with it falls under the jurisdiction, so conventional cigarettes also fall, in addition to FDA, they also fall under the jurisdiction of the Alcohol, Tobacco Tax and Trade Bureau, also known as CTB, whereas vaping products don't. So again, there are some legal provisions that apply to only conventional cigarettes and other more traditional products, and some that don't apply to vaping products. However, while at present you don't need a license, and there is obviously no FDA license for retailers, and they won't have a license for retailers, in the future, your state might require one day a license for vape shops, and I cannot tell you when and where and what states might be considering that, but it's important to stay informed. I expect that might be coming, and it's again a matter of state law, and really state laws and federal laws can be complementary. So you really need to keep informed and make sure of developments. It's also a good opportunity for you to engage with your local representatives and legislators. Much like, I'm taking this opportunity to tell you that not all is lost. Of course, this rule as well can be improved upon. And in fact, there is a very valuable initiative called the Cole-Bishop Amendment that we at Nicopure Labs are supporting through our participation in the Vapor Technology Association. And that initiative would really ease some of the burdens imposed by the Deeming Rule. So again, certainly there are some ways to engage politically for you as retailers that I would urge you to pursue. But more about that on a different occasion. Let's go back to our questions. So of course, we're talking about retailers here, but the question on everybody's mind is, we all hear that that it's going to be very expensive for manufacturers to comply with certain requirements of the Deeming Rule. So while retailers, all they need to do is follow the law, age verification, no vending machines in venues with minors, and basically keeping good track of their records, and of course line inspections. If you think of manufacturers, there are many more obligations that are burdening manufacturers, and one of them is the obligation to submit what's called a pre-market tobacco application by 2018, and also by this December there is a very simple filing which is called a registration and the product listing. So those applications themselves, FDA doesn't charge anything for them. However, if you want to file a PMTA by the deadline of August 8, 2018, if you're a manufacturer, then of course that PMTA is really a scientific application. It's a dossier, a file that has to have a lot of data about the product, chemistry data, toxicology data, in vitro and vivo studies, possibly human studies, and conducting all of those studies and putting together the application is an extremely costly process. I've been personally through similar applications with the FDA through the substantial equivalence, which is a shorter, a more abbreviated version of that, and certainly that in itself was extremely costly, extremely time-consuming. It requires a very specialized level of expertise, large teams of people. And so when you hear about the cost to manufacturers, it's really the cost you pay to the experts, to the consultants, to the lawyers ultimately, but mainly to experts in human studies, in toxicology, chemistry, product design, to write, first of all, to conduct the research, and then to write and submit this application. And that's the cost. And you've heard about FDA estimating this cost as being $300,000 per product. I believe actually it's going to be higher. And I believe that very few companies, one of which is us, will be able to comply. But remember, there's also no guarantee of an outcome. And so that's a lengthy process and an investment that companies have to make. And the fact of the matter is most manufacturers won't be able to sustain that kind of expense. But again, there is a 2 years deadline. There are some opportunities to perhaps change that requirement in the rule. One of them is, of course, as I was mentioning, the Cole-Bishop Amendment. Of course, as you also know, Nicopure Labs was the first company to actually file a lawsuit against the FDA the very moment when the Deeming Rule was published back in May. And really there is an opportunity there as well, although litigation is never certain. So now that I've mentioned that, one of the questions that we just received was perhaps a quick update on litigation, and here is what I can provide. So as I mentioned, we were the first time to sue. After a few weeks, another group of companies actually joined, and that litigation, our litigation, the Nicopure Labs and others versus FDA, is going on an expedited schedule. What does that mean? The expedited schedule means that we have filed our motion for summary judgment at the end of last month, and the government is going to answer to our motion for summary judgment on August 16th, which is just next week. After the government answers, we provide our answer to their answer. The government gets one more shot to write back by September, and on October 19th we have our arguments, and then everything is in the hands of the judge, who will take probably a few months to issue her decision. And basically at this point there is nothing else we can do because we already filed our briefs, and they're of course public. You can read them. I cannot emphasize enough how grateful I am to the management here at Nicopure Labs, that they actually realized what an important responsibility it is actually to undertake this step and to challenge. It's certainly I'm very humbled by their trust in our department, and also I'm very humbled by the fact that they realize that it's really not only about Nicopure, it's really about the entire industry. And that effort hopefully will bear fruit. In any event, we have to stay the course, and for the duration of the litigation, the Deeming Rule is still in effect. And depending on the outcome, it may still continue to be in effect. So therefore, we really have to follow the law, and which is why we're engaging with you. We're engaging with FDA and other regulators to make sure that we understand exactly all of the requirements. So here are some more questions that we just received, there is perhaps a few topics of interest. So another question is, are we allowed to physically touch customers' equipment? And can we troubleshoot problems? And so I think there's a few scenarios here. So the most straightforward scenario is a consumer buys a device from you and some spare parts. They bought them, they paid for them, maybe walked out of the store, comes back, the consumer comes back, and then they say, you know, can you please show me how to replace the coil? It's up to you if you want to do that. It's his product, you know, you're not reselling it. That in itself wouldn't constitute manufacturing. Do you want to take the responsibility, however, to replace that coil for him with a coil that he bought, so not with your own, with his own coil? You know, and the responsibility would mean that if the product malfunctions, the consumer is going to say, wait a second, you put that coil on my device. Yes, it was my coil, my device, but you assembled them for me, so the product malfunctioned, maybe you didn't assemble them correctly. So again, think very well before you engage in that type of activity, not because of FDA, but because of other types of liability that you may be incurring. Now, another scenario is, you know, you have a product, the consumer takes it home, comes back, says it doesn't work. Well, repairs are really not addressed in FDA's rule. And a repair really could be construed as representing manufacturing, but because it really changes the property of the product. But again, that's not addressed. In principle, you know, I would advise you not to do it. I would advise you to just suggest that the consumer either gives back the product for replacement, or in some way or form, you basically direct him how to repair it, but don't do it yourself. It's your judgment, your call. Again, that's not addressed anywhere. I would be wary about doing it because, again, it could be construed that you've tampered with the product. If there is any malfunction, then, of course, the liability could be yours. And that's really your risk to take. In brief, you can assist customers, but it's really at your own risk, and all kind of consequences can occur. Excuse me. More questions about whether we can sell individual spare parts. And you know, some spare parts such as these don't necessarily come in a box. Depending on the manufacturer, you may have spare parts that are just, you know, in a bulk box, and you can sell them by piece. And typically with conventional tobacco products, they're all packaged, right? Cigarettes, they come in a package. Of course, these products now, all these little devices, or I should say parts of devices, the battery itself, all of these, unfortunately, according to the new rule definition, are now tobacco products. Do they have to have a box? No, not really. You can, of course, sell them without a box, but you should sell them as is. You shouldn't tamper with the product itself, so you shouldn't fiddle with it, open it, replace something, and then sell it to the consumer, because that would represent manufacturing. But you can continue selling them. Now, of course, if you have a contract or some kind of an agreement with your distributor where the distributor says, I'm selling you packs of 5, and I want you to sell them in 5. So that's a contractual matter. It's not something, of course, that we can address here. But if you have these, and the intention is to sell one at a time, and there is a price associated with it, of course, you can continue to sell them. Remember, every one of them is a tobacco product. It's separate. What about charging batteries? So, you know, that's, again, something that has not been addressed in FDA's rule. And remember, FDA is new at this, as we are as an industry, but FDA, in addition to that, also doesn't seem to have taken the time to understand the industry very much when they wrote the rule, unfortunately. So if a battery is not charged, now, remember, that's the same situation when you buy an iPhone, right? You buy an iPhone, and it's really the same type of interaction. Buy the iPhone, it's in a pack, the retailer sells it to you as is, and if you want to charge it, you as a consumer charge it at your own risk. I don't see the reason why the store should charge the battery for the consumer, because, you know, in our everyday life, we purchase a lot of products where the batteries are really not charged. Again, the iPhone being one of the examples. Some products may have instructions, right, that say, you know, charge it for X number of minutes. But some products might not, and of course it's perfectly all right to share your personal experience or information provided by the manufacturer about how long the battery needs to be charged or how to charge the battery. Going as far as charging the battery for the consumer, You know, unless he asks you, well, may I use your plug in the store to charge it, and you do it as a courtesy, again, I wouldn't necessarily encourage it because, you know, what if the battery malfunctions and somehow, you know, that liability gets assigned to you. But remember, it's just like with any other product that comes with the batteries that's not charged. Once the consumer has purchased it, it's really his, and he can do whatever they want with it. Sampling. Well, what about if you have a taste bar? Sampling again. Can they use my equipment to sample? Of course. You're going to charge the consumer for really inhaling the flavor, and of course they can use your equipment. Now, how you're going to go about obviously keeping that equipment clean, or you know, having disposable mouthpieces, that's your choice. But certainly you can use your own equipment, provided that you charge something for the samples. So let's check another question. Yes, so is there a deadline for retail shops to have a POS system in place? And again, remember, FDA doesn't really cover that. So in principle, no, there is no deadline. But practically, you know, traceability is very important to be able to pay your taxes, especially in those states where there are taxes, or to be able to really track the products that you've sold in case of a recall. Probably will be very helpful to have the necessary POS equipment. So jumping forward a little bit to questions about taxation. We have a little bit of misunderstanding here sometimes because you know, FDA does not deal with taxation. FDA does not deal with taxation, doesn't deal with vaping bans. Those are generally the realm of the states. There could be also federal taxes imposed at some point. But certainly taxes could be levied by your state or even local government. You really have to ask and be informed as to what taxes are applicable locally. It has nothing to do with the FDA. You really need to follow that at local level and collect the taxes in the manner, like for sales tax, right, in the manner in which it is provided in the law. And it will differ from state to state. Some states have already imposed quite unreasonable taxes, but you really need to become familiar with that at local level. Certainly, there could also be vaping bans that affect you know, perhaps your store. I don't think that's the case today, but in any event, you really have to be familiar with those restrictions, and those have nothing to do with the FDA. The other question that we receive is, are we allowed to give consumers the product and have the consumer handle the product before deciding to purchase them? And that's a very legitimate commercial activity. Of course, I would purchase something that I've never owned before at least taking a closer look at it. But again, my advice to you would be to have a display model and show it to the consumers. Or if they're convinced they're going to purchase a closed box, open the box and give it to them to play with. But really, I would not engage in reassembling the product because that could constitute manufacturing. So the most important question that we heard, and it's a recurring question, is it true that we as retailers cannot discuss anymore the benefits of vapor products with our consumers, or the health hazards associated with smoking cigarettes? And I will tell you very clearly, yes, you can continue to discuss the health hazards associated with cigarettes. In fact, that's part of consumer education. That's why this product is here, because there is another product called the cigarette, which is extremely harmful to health, undoubtedly so. And of course, you can tell people, you know, cigarettes are harmful for your health. This is an alternative. However, you can always offer your individual opinion and experience in conversation with your consumers, and those are generic statements. You know, you can share your personal experience when you tried vaping products, and nobody can prevent you to communicate that kind of information. However, manufacturers are not allowed to make specific statements or to label the product in a manner that suggests that a specific brand product is safer, lighter, or lower risk than another product. So let me give you a very concrete example. You can have in your point of sale in your store on a billboard excerpts from research Dr. Farsalinos, Dr. Polosa, whoever you want, the Public Health Income Report, which say that e-cigarettes as a category are safer than cigarettes. And if there is such research, you can feel free to post it in your retail store or on the website. That's not your research. It doesn't talk about a particular product. It talks about a product category. And that research is out there in the open. It's been published in scientific journals. So you're not really making a statement yourself. You're just sharing with your consumers, with your audience, information that is out there that was developed by reputable researchers. It is even appropriate for me when I go to a conference, and I go to many of those, to discuss scientific research that shows comparative benefits of vaping products in general, as long as you don't make a statement regarding a particular brand or product. So for instance, I can go to a conference and say, yes, Public Health England and the Royal College of Physicians have said unquestionably vaping products are 90%, 95% less risky than conventional cigarette products. It's something that somebody else has said. There is research to prove it. However, I cannot go say Halo is 95% safer than Marlboro. I cannot say that. That is not something appropriate to say, first of all, because you cannot really quantify it quite so. But that's the type of specific statement about a specific product that is not preempted under the rule. But I can say, for instance, according to Professor Farsalinos, e-cigarettes expose users to substantially less toxicants than conventional cigarettes. That's fine to say. In fact, there is also case law to that effect from about 6 years ago that talks about, in fact, you are allowed to talk in conferences about comparative risks of products. And just so you know, even FDA talks about comparative risks of products, and even FDA understands that e-cigarettes and vaping products as a category are, in fact, less dangerous to the individual. In fact, Mitch Zeller, the head of the Center for Tobacco Products, in fact, has actually said that. So certainly, those kind of general statements you can continue to make, as long as you're not peddling a particular product to say, this product is safer than that product. And I would never advise you to that. So as a side note, there is another question about generally, well, has FDA said which products are acceptable and which not? Has FDA declared this type of product, maybe closed systems versus open systems, should stay on the market? And no, there will be never such blanket statement. FDA will review products one by one. There is a deadline to file pre-market applications in 2018, and then FDA will review those applications. So certainly FDA will make a product-specific determination, not a blanket determination as to a category of products. So for now, as I said, there is not one single category that is banned or you cannot sell. Again, FDA will have to issue individual orders ordering a particular product off the market, and that's going to take a few years to happen. So another question is about custom coil building. Somebody asks, we don't produce our liquid or hardware. However, FDA defines a manufacturer as an entity that would make, modify, mix, manufacture, fabricate, assemble, process, label, repack, relabel, or import a tobacco product. So the moment you process or repack or relabel a product, you're a manufacturer, and therefore you have to comply to many more requirements under the Deeming Rule. And performing custom coil building in your store appears to fall under the definition of manufacturing. Then the follow-up was, well, how strictly will FDA enforce that? And like with all laws, always FDA will eventually enforce a rule. It's not going to happen tomorrow. You shouldn't expect an army of FDA or state contracted inspectors descending on your stores tomorrow to check what you're doing. That's, for reasons of practicality, it's not going to happen in one day. But there is no such thing as strict or less strict enforcement. If it's a rule, there's a rule, and then there's enforcement. When it comes, in other words, whether you're caught, that's a different story, but by and large, if there's a rule, you have to follow it and expect that it will eventually be enforced. I think our biggest frustration with the FDA is really going to be that we're going to see a lot of activity that is not acceptable anymore, that is going to still take place, and there's going to be a lot of frustration that FDA will not enforce fast enough against those people. And I think we already shared in some of that frustration because we believe we're investing a lot in compliance, in staffing, in conducting our business to the highest levels, and we know not everybody does that. As a general question, we're often asked, well, what about if I get my liquid in bulk and if I now pour it into bottles and seal the bottles and sell them to consumers? And that really, if you remember the definition of manufacturing that I just mentioned a minute ago, basically that definition or repackaging the bulk liquid would fall under the definition of manufacturer. So manufacturer would be somebody who makes, modifies, mixes, manufactures, fabricates, assembles, processes, labels, repacks, relabels, or even imports the product. And so by putting bulk liquid in bottles, you're really repackaging it and possibly also relabeling it. And that's something that, of course, as of August 8th, you cannot introduce new products on the market without FDA's authorization. So engaging in that kind of manufacturing both exposes it to additional requirements and also raises the question, am I now creating a new product that I'm putting on the market after August 8th without FDA's authorization? Same thing if you have, basically generally it's not a good idea to tamper with a bottle of liquid that has been manufactured because simply the manufacturer has intended it to be sold in a certain way. So reducing or altering, increasing the level of nicotine, that involves manipulating the product. And manipulating the product means manufacturing. And again, you should not be introducing new products that did not exist as of August 8th on the market. If that manipulation takes place in your vape shop, then you're not only a retailer, you're also a manufacturer. So the two are not mutually exclusive. Nicopure Labs has an online retail site, and therefore we are a retailer, but we're also a manufacturer. Much like a vape shop that engages in relabeling, mixing, and so on is a manufacturer, even if they're also a retailer. And therefore, you really should refrain from engaging in that activity. So there is a generic question about the effects on the rule on the industry as a whole. And let me spend a couple of minutes on that because we're really going to see a few changes in the future. So as I mentioned, the retailer's obligations are relatively self-contained and they're relatively straightforward in terms of what you have to comply with. As a manufacturer, however, there are a number of deadlines that will take place over the next 2 to 3 years. And bear in mind that when those deadlines happen, FDA doesn't really confirm or doesn't really publish a list of manufacturers that have actually complied with those deadlines. But at the same time, you will notice that a lot of manufacturers in the future will decide that those requirements are too onerous and that they may decide not to be on the market anymore. So everybody talks about the impact on the industry. We expect to see attrition in the industry, though not immediately. And we understand that there is going to be a great deal of uncertainty still going forward. Just to give you an example of what happened with the conventional tobacco industry, the Tobacco Control Act came into force in 2009. And between 2009 and 2016, there were a lot of enforcement actions against retailers for age verification violations. Those warning letters that I mentioned that you should really look up on the FDA website. Some of the warning letters, especially for repeated violations, were escalated to civil money penalties and up to what's called a no-sale order. Again, on FDA's tobacco website, there is ample discussion about those. There are examples of civil money penalty enforcements. So you can get an example as to what are the costs associated. When you get a warning letter, that doesn't come with a money penalty. And that's usually the first step. You better don't repeat that same violation. That's all I can say. The civil money penalties, there's a range depending on how many times you violated and so on. Again, go to the website and make sure you verify all of that. Between 2009 and today, we also saw a number of guidance documents coming out of the FDA because the law is not clear. Even now, after 7 years, and I've been in this industry for a very long time, it's not 100% clear exactly what FDA needs to do and what the manufacturers need to do under every section of the Act. So the way FDA communicates with manufacturers and retailers is in several ways. One is the guidance documents. And the guidance documents describe FDA's thinking and interpretation of the statute at a point in time. And even that understanding can change. So for our industry, in the near future, we are going to see more guidance documents being issued by the FDA. They're usually published on the FDA website, but you can also subscribe. There is an email that you can, an email alert that you can set up if you subscribe to FDA's online notices. Again, navigating FDA's tobacco products website, you can find that link. And FDA can actually send you emails every time there is a new guidance or a new communication, a new webinar, and that will enable you to keep updated with the new guidance documents. Also, every time when a guidance document is published or perhaps a new rule, because remember the Tobacco Control Act actually gives FDA exclusive authority, primary authority over tobacco products, primary authority. And it allows FDA to issue regulation under the Tobacco Control Act. So the deeming rule is not the last rule we're going to see coming out of the FDA in connection to our industry. Whenever a guidance document or a proposed rule is published, usually in the Federal Register, there is usually a comment period where everybody's invited to submit comments. And you know, to quote actually Mitch Zeller, the head of the Center for Tobacco Products at the FDA, the guru of all tobacco products, this is not a spectator sport. If you want to have an impact in changing these rules and changing the guidance, every time FDA publishes such document, whether it's a proposed rule or guidance, you should file your formal comments to the docket. And I know it sounds complicated, but it's really quite simple. There's every time there is a guidance, at the bottom of the guidance, there is instructions as to how to file those comments. And you should certainly consider, whether individually or through your trade associations, to participate in that rulemaking process. Because if you don't participate, really FDA has no obligation to understand our industry, to understand our issues. So it's very, very important that you submit comments. Furthermore, even when a guidance document is finalized, FDA oftentimes will require things in addition to that guidance document. So enforcement is really very fact-specific and very case-specific. You may think that the same situation happened to someone else, whether it's a manufacturing issue or a retail issue, but that's really not always the case. You never really know entirely the facts of the case. So before jumping to conclusions, you should really make sure that you understand your business. You make sure that if you receive a letter from the FDA or any kind of official communication from the FDA, be diligent, answer it. FDA usually provides you the contact person where you can call or write for further clarifications. And I would strongly advise you to take advantage of that. Also, on FDA's website, there is a link and there is information for retailers as to where to address questions to the FDA. And I would say ultimately it's FDA and FDA's interpretation of the law that really matters. Some things are clear, black and white. Thou shalt not sell to minors. There is no other way to put it. But some things are not so black and white, such as, you know, some of the things you're asking about, well, can I repair batteries? Well, that's not addressed. So you should really take the time and try to communicate directly with FDA and try to get some written answers, because every answer is going to be fact-specific, and not one single answer may be applicable to all situations or all manufacturers, and you should really try to engage with them. Now, I'm aware that we have not addressed a lot of your questions. I really hope that those that we have addressed or that we have selected give you a little bit more comfort and understanding. But generally, as retailers today, you really don't have a whole lot to worry. I would say, unless you engage in manufacturing, because for you as retailers, it's a little bit more straightforward than for manufacturers. We promise to keep you informed in the future. I think our next opportunity to discuss will be when FDA issues additional guidance, or if there is any meaningful developments, whether politically or in litigation. But for now, thank you very much for your attention. It's our pleasure to work with all of you, and thank you for your time, and see you next time. Have a great day.